My sister delivered it the way she had always delivered difficult things, without apology and without hesitation, with the particular certainty of someone who had rehearsed the performance often enough to mistake it for truth. She stood beside her attorney in the Jefferson County probate court in Louisville and told the judge that I had been, in her measured phrasing, functionally absent. That while she had rearranged her life, her apartment, her daily schedule to be present for our mother, managing the appointments, coordinating with the memory care staff, handling the banking, sitting through the hard middle of the night calls from the facility when our mother had a difficult episode. I had remained in Nashville, 2.5 hours away, calling on Sunday afternoons when it suited my schedule, and arriving on weekend mornings when the mood was manageable, and leaving before anything became uncomfortable. She said I had never understood what real sacrifice looked like. She said the documents, the amended trust, the revised beneficiary designations, the account restructuring, the family home now transferred to an LLC, all reflected what our mother had genuinely wanted once she had finally understood who had truly been there for her. She said I was contesting these arrangements not out of principle, but out of wounded pride. I sat at the petitioner's table and said nothing. The judge was the Honorable Raymond Ferris, a compact man in his late 60s with reading glasses he kept pushing up the bridge of his nose. He had the unhurried quality of someone who had presided over enough grief-adjacent hearings to understand that the first version of a story is almost never the complete one. He let my sister's attorney, a man named Ashton who had the practiced composure of someone accustomed to uncontested proceedings, finish his prepared statement. Then he set his pen down and looked at me with a quiet directness. "You're the co-petitioner." "Yes, Your Honor." "Your counsel will speak on your behalf?" "Yes." He nodded once, the way people nod when they've already begun the process of recalibration, and turned back to the file. "My name is Harlan. I am 63 years old. I spent 29 years as a federal bank examiner with the Office of the Comptroller of the Currency. The last 11 of those years I served as a senior examiner specializing in trust account compliance and the financial exploitation of elderly account holders. During my career, I reviewed more than 400 cases involving the irregular transfer of assets from vulnerable adults through instruments including powers of attorney, beneficiary designations, revocable trusts, and LLC structures. I had testified before the Senate Banking Committee on 2 occasions. I had trained state-level regulators in Kentucky, Tennessee, Indiana, Ohio, Georgia, and North Carolina. My sister's attorney had described me, in his opening statement, as a retired federal employee in finance. My sister had not corrected him. Our mother is 84 years old. She has been a resident at Hearthside Memory Care in the St. Matthews neighborhood of Louisville for 22 months. Before that, she lived for 61 years in the same brick craftsman house in Crescent Hill. A dogwood tree in the front yard that bloomed every April, and a kitchen where she kept a weekly planner open on the counter beside her coffee and wrote down everything she didn't want to misplace, which, over the last several years, had become more and more. She was a meticulous woman. She had spent 30 years as an office manager at a civil litigation firm, and she understood the weight of documents with the seriousness of someone who had watched careless paperwork cost ordinary people real things. After my father died 15 years ago, she spent 6 careful months putting her affairs in order with a probate attorney she trusted. She told me once, standing at the kitchen counter with the planner open beside her, that she intended to be clear, while she still could, so that no one would have to sort through confusion later. She meant it as a gift. She had always tried to give things before she was asked. My sister moved back to Louisville 6 years ago. She had been living in Atlanta since her second divorce and said she wanted to be closer to family. Our mother welcomed her the way she always welcomed people who were starting over, without conditions, without invoices, without expectations attached. Within a year, my sister was doing the grocery runs. Within 18 months, she had offered to take over the banking to spare our mother the logistics. Within 2.5 years, she had been added to every account as a joint holder, had been designated primary agent under a new durable power of attorney, and had become the listed contact for our mother's investment advisor, insurance carrier, and primary care physician. I was in Nashville. I drove up most weekends. I called every evening. I sat with my mother during medical appointments when I could arrange it, and I listened when she talked about the old neighborhood, about my father, about a trip they had taken to Savannah in 1987, that she mentioned so often I had come to understand it occupied a particular place in her memory. The kind of place where details stay clear long after other things begin to blur. After her Alzheimer's diagnosis, I started keeping notes, not because I immediately suspected what was happening. I kept notes because that is what I do. 29 years of federal bank examination doesn't dissolve with a retirement party. I tracked things by instinct the way some people check doors twice before leaving the house. The first irregularity appeared 16 months before the hearing. A $12,000 transfer from my mother's primary savings account to an account number I didn't recognize on the quarterly statement I still had access to as a secondary party. I called the bank and identified myself. I was told the destination account was associated with a business entity. I wrote it down. Over the next 8 months, I found 6 more transfers. Each one was structured below the federal currency transaction reporting threshold. Each went to the same account. The business entity, I confirmed through a Kentucky Secretary of State search, was a single-member LLC for which my sister was the sole registered officer. I did not confront her. I did not call the bank again. I submitted formal written requests on letterhead, identifying myself by name, by relationship, and by professional background, for copies of every document my mother had signed in the preceding 2 years. Several of those documents came back with my mother's signature on dates that corresponded to documented periods of severe cognitive decline. I had requested her clinical records through a formal written process, and the neurologist's notes were specific: impaired judgment on this date, reduced executive functioning during this window, acute disorientation lasting several days. The trust amendment that had transferred the majority of my mother's assets and named my sister as primary beneficiary had been signed on a Thursday morning during a window the neurologist had flagged, in writing, as a period of significant confusion. I photographed everything. The originals remained where they were. During visits to Hearthside, I listened to the staff. Not with pointed questions, just with the kind of patience that makes people feel they can speak plainly. One afternoon, nurse told me, without being asked, that my sister's visits sometimes seemed to leave my mother unsettled, that she had seen my mother crying on at least 2 occasions after my sister left, and that my mother had asked her repeatedly, on different visits, where I was. I wrote that down too. The planner was on the nightstand. I found it on a Sunday afternoon in early November during one of my weekend visits. My mother was napping in the late afternoon light, her breathing slow and even. I was sitting in the chair by the window with a book I hadn't opened, watching the thin November sun move across the floor. At some point my eyes moved to the nightstand, and I saw it there beside the lamp, a small spiral-bound weekly planner with a pale floral cover, the same style she had used every year I could remember. I opened it. I told myself I was just checking the way a person glances at a countertop calendar without deciding to. The way habit moves before intention catches up. Most of what I found was ordinary. Appointment times. Notes to herself. A reminder to tell me to bring the dark roast next time I came because the facility coffee wasn't right. A small entry that said simply, "The dogwood should be blooming by now. I hope someone is looking after it." But 3 entries were different. The first was dated the same Thursday I had already identified from the documents, the day the trust amendment had been executed. The handwriting was larger and less even than her usual careful script. She had me sign something today. I asked what it was. She said it would protect me. I signed it. I don't think I read it well enough. I should have called H first. I hope I didn't make a mistake. I set the planner on my knee and looked out the window for a long time. The second entry was written 10 days later. I've been thinking about what I signed. I asked about it, but she said it was handled. I looked in the drawer, but there was nothing there. H would know if something was wrong. He always understands these things. I should have called him. My chest tightened in a way that surprised me. I had spent nearly 3 decades reading documents that described real harm to real people, and I had read them with the professional distance that the work required. My mother's handwriting would not accommodate that distance. The third entry was addressed to me directly. She had written it in a different hand than the others, slower, more deliberate, as if she had thought through each word before committing it to the page. She must have known I read through the planner when I visited, or hoped I would. H. If you find this, I want you to know that my mind goes in and out, but I know when something isn't right. I know something happened with those papers, and I don't think it was the way it should have been. I didn't want to make trouble. You know how I am. But I kept writing it down because you understand these things. You always have. Look at it carefully and do what is right. That's all I am asking. I love you. Don't let her see this. I closed the planner. I sat with it in my lap while the late afternoon light faded and my mother slept, and the facility settled into its quiet early evening sounds. A meal cart in the hall, someone's television down the corridor, a nurse's soft voice in the next room. When my mother woke up, we talked about Savannah. She described the hotel, the way the squares looked in the evening, a restaurant where the food had been better than anything she'd expected. I held her hand and listened until she was ready to sleep again. I drove back to Nashville. I called my attorney the next morning. Ms. Vance had been practicing estate law in Louisville for 24 years. She asked questions the way a careful person asks questions, not to hear herself talk, but to understand exactly what she was working with. When I described the planner and read her the 3 entries over the phone, she did not react emotionally. She asked about the handwriting and its consistency with my mother's usual writing, about the planner's location, about the clinical timeline and its correspondence to the dated entries. Then she was quiet for a moment. "Your mother documented her own uncertainty at the exact moment it occurred," she said. "That's not sworn testimony, but to a judge, it is something significantly more than nothing. It describes the state of mind of the person whose capacity is at question, in her own words, at the relevant moment." She paused. "Your sister has almost certainly already engaged counsel. These arrangements don't tend to hold well when someone with your background starts making formal records requests." 3 weeks later, my sister filed a motion with the Jefferson County Probate Court. She alleged that I was contesting the estate documents in bad faith, seeking to override our mother's clearly expressed wishes for reasons of personal financial interest. She framed it, in the filing, as protecting a vulnerable woman's final intentions from a brother who had kept his distance when it mattered and was now inserting himself at the end. In the weeks before the hearing, I did 2 things the circumstances required. I contacted Kentucky's Cabinet for Health and Family Services, Adult Protective Services Division, and provided a formal written report. The transfer records, the LLC registration, the dates of execution against the clinical assessments, the planner entries, the staff observations. I did not request any particular action. I provided information and trusted the process to respond. They opened a preliminary inquiry within 2 weeks. I also spoke again with the director at Hearthside and asked whether the facility had visitor records corresponding to the dates of the transfers. They did. 2 of the transfer dates matched signed visitor logs in my sister's name. One staff member agreed to provide a written statement describing my mother's state on one of those afternoons, confused and anxious and asking repeatedly to reach her son. My mother had trusted me to look. I looked. The hearing was on a Tuesday in February. The courtroom on the 3rd floor of the Jefferson County Hall of Justice had the particular stillness of a room where serious things are regularly decided. Tall windows, wooden benches, the kind of flat winter light that makes everything feel slightly slowed down. There were no spectators. My daughter had driven in from Cincinnati the night before and sat 2 rows behind me. She had been quiet all morning. In the hallway before the hearing, she had held my arm for a moment and said, "I know who you are, Dad." That was all. It was enough. My sister sat across the room in a dark blazer, composed in the way that requires effort. Ashton opened with a confident statement. Her years of proximity, her consistency, her daily presence. He described me as someone who had maintained a cordial but distant relationship with our mother while choosing career and comfort over family obligation. He said the documents reflected a genuine and considered expression of my mother's wishes, made over years of close daily care. He did not mention what I had done for 29 years. When Ashton finished, Judge Ferris looked at the room with the patience of a man who had found that patience was usually rewarded. He looked at me. "Before we proceed, your attorney's filing references a professional background. In your own words, please." I stood. "I was a federal bank examiner with the Office of the Comptroller of the Currency for 29 years. For the last 11, I served as a senior examiner specializing in trust account compliance and the financial exploitation of elderly account holders. My work involved reviewing improper transfers of assets through powers of attorney, beneficiary designations, revocable trusts, and LLC arrangements. I reviewed more than 400 such cases during my career. I testified before the Senate Banking Committee twice. I retired 3 years ago." The room was very quiet. Judge Ferris turned to Ashton. "Counselor, when you prepared this filing, was this background part of your assessment of the co-petitioner?" Ashton was still for too long. My understanding was that he was a retired federal employee in finance. Judge Ferris did not look amused. He looked like a man who had just completed a recalculation and was beginning to understand its full implications. "Mrs. Vance," he said, "you may begin." Ms. Vance did not pace. She placed both hands flat on the table and spoke with the clarity of someone who does not need to perform certainty because they have the actual thing. She walked through the transfer records, 7 transactions, 14 months, totaling $73,000, all routed to the same LLC registered to my sister, no documentation of services rendered, no invoices, no agreed consideration. She walked through the trust amendment and the beneficiary changes alongside the corresponding clinical records. Noting that each critical document had been executed during a window, the treating neurologist had documented as a period of significant cognitive impairment. She noted that in Kentucky, testamentary capacity is evaluated at the moment of execution. She noted that no independent legal counsel had been present for any of these signings, that the sole beneficiary had been present for all of them. Ashton objected several times. Judge Ferris overruled him each time without looking up. When Ms. Vance said she had one additional item to present, Ashton's posture shifted slightly, the barely perceptible adjustment of someone who has just understood the scope of what they've walked into. Ms. Vance described the planner plainly, what it was, where it had been kept, who had found it and when, and what it contained. She submitted it as an exhibit. She asked the court's permission to read 3 entries into the record. Ashton objected on hearsay grounds. Judge Ferris considered it for a moment. A written record made by the grantor contemporaneously with the relevant events, documenting her own uncertainty regarding documents she had just signed, falls within established exceptions for state of mind. Overruled. Ms. Vance read the 3 entries. She did not change her voice, did not slow down for emphasis. She simply read them into the record the way you read something that is already carrying everything it needs to carry. She had me sign something today. I asked what it was. She said it would protect me. I signed it. I don't think I read it well enough. I should have called H first. I hope I didn't make a mistake. The courtroom was very still. When she finished all 3, Judge Ferris did not look at my sister. He looked at the window. Then he looked back at the file and folded his hands. My sister spoke without being recognized. She was confused constantly, she said, and there was something hard and unfamiliar in her voice. Half the things she wrote don't make sense. That notebook doesn't prove anything. Judge Ferris raised one hand. Ma'am, you are represented by counsel. Please be seated. She sat down slowly. Counselor, the judge said to Ashton, can your client provide documentation that independent counsel was present on behalf of the grantor when these instruments were executed? Ashton paused too long. Not at this time, Your Honor. Judge Ferris looked at the room. I am suspending these estate documents pending a full accounting, he said. The asset transfers in question are frozen. I am requesting Adult Protective Services submit their preliminary findings within 30 days. I am also referring this matter to the Jefferson County Commonwealth's attorney for review under Kentucky's financial exploitation of an adult statute. He looked at my sister for a moment. The planner your mother kept was not the record of a woman who didn't understand what was happening to her, he said. It was the record of a woman who understood something was wrong and trusted the right person to find it. He struck the gavel. The sound landed without ceremony the way true things land. In the corridor outside, my daughter found me and held on without saying anything. When she stepped back, her eyes were steady. The particular steadiness I had recognized in her since she was small, the way she gathered herself on the other side of something hard. Grandma knew, she said. I nodded. I didn't trust my voice. My sister did not speak to me that day or for many months after. Her attorney withdrew within 6 weeks. She retained new counsel. Adult Protective Services submitted their findings on schedule, describing a pattern consistent with financial exploitation of a vulnerable adult, systematically documented across the timeline. The Commonwealth's attorney filed charges under Kentucky Revised Statute 209.99. My sister rejected the first plea offer and the second. Her new attorney made arguments about caregiving complexity, about shared intentions and informal arrangements, about how close families sometimes handle finances in ways that look irregular from the outside. Each argument ran against the transfer records, against the LLC structure, against the clinical assessments, against the planner. She accepted a plea to a felony exploitation charge 9 months after the hearing. 3 years probation, full restitution with interest, a permanent prohibition from serving as agent, trustee, executor, or in any fiduciary capacity for any person. The LLC was dissolved. Every asset transferred through it was returned. The family home in Crescent Hill was restored to my mother's estate. It sold the following spring. The harder things were the ones that didn't appear in any court document. My sister and I have not spoken since. I don't know yet what shape that silence will eventually take. I have stopped trying to predict it. There are things you can correct and things you can only move through, and sometimes the only honest answer to what comes next is that you don't know yet, and that's all right. My daughter and I drove to Crescent Hill the morning after the estate was formally settled. We parked on the street and sat for a while looking at the house, the brick front, the bare-branched dogwood my father had planted the year my sister was born, the kitchen window where my mother had kept her planner open beside her coffee for 6 decades. I want to do something, my daughter said, but I don't know what. I know, I said. I had brought the planner. I had made full copies, scanned every page carefully. The original had served what it was meant to serve. I thought about keeping it, but my mother hadn't written in that planner as a keepsake. She had written in it the way she had written in every planner, because she needed to move things out of her mind and onto paper before they slipped away. The purpose of these particular pages had been fulfilled. I walked to the front step and set it there, where the new owners would find it. They wouldn't know what it was. Maybe one of them would open it. Maybe not. It didn't matter. What mattered was that she had written in it exactly the way she had always lived, carefully, precisely, trusting the right person to be paying attention. I looked at that porch for a long time. The dogwood was still bare in the February light, but the buds were there on the lower branches. In 6 weeks, maybe 8, it would bloom the same as it always had. I got in the car. There are things that restore themselves, and things that don't fully come back. My relationship with my daughter has deepened in the way that only happens when you've been through something real together and found yourself on the same side of it. Not because you planned it that way, but because it turned out you were both built the same. What I return to when this period comes back to me is not the hearing. It's not the outcome. It's my mother in that kitchen every morning, with the planner open beside her coffee. 60 years of small, careful notations. She had done it because she believed that things written down stayed true in a way that things held only in memory could not always manage. And in the moments that had mattered most, at the end, she had written down the truth one more time, not for herself, but for me, in her own careful hand, in the place she knew I would eventually look, because she had always known I looked carefully. She had told me something close to that once. Years ago, on the back porch of the Crescent Hill house in the early summer, when the evenings were long and there was no particular reason to be anywhere else. She brought out iced tea without being asked. We sat without talking for a while. You always were the one who noticed, she said, in the comfortable way she said things when she wasn't making a point, just observing. I didn't say anything. We just sat there until the light was gone, easy in the kind of quiet that belongs to people who have known each other long enough not to need to fill it. That, too, was enough. If this story found you at a difficult moment, if something in it recognized something in you, I'd like to know. Leave a comment. Tell me what time it is where you are. These aren't stories about winning. They're about what holds when the people we love become vulnerable and what it means to be the person they trusted with the hardest things. If that kind of story matters to you, there are more ahead. I'd be honored to share them.